Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. In this episode, we discuss the Constitutional Court's decision in Samu versus Minister of Cooperative Governance and Traditional Affairs. Now, this case came to the Constitutional Court after the Labour Court's judgment, where they declared that Section 71B of the Local Government's Municipal Systems Act is unconstitutional and invalid. Essentially, the impugned provision, which had previously prohibited only senior municipal employees from holding political office, was amended in 2022 to extend that prohibition to all municipal employees. This meant that technicians, secretaries, clerks, gardeners, drivers, and other staff members far removed from decision-making powers could no longer hold political office. Now, the majority of the Constitutional Court agreed that the restriction could not be justified and confirmed the Labour Court's declaration of invalidity. The minority judgment held that the respondents had done enough to justify the limitation as reasonable and justifiable in an open and democratic society. So in today's discussion, we are reflecting on the court's decision, which ultimately reaffirms the right to political participation for workers, whilst also situating it within the broader context of dysfunctional municipalities and what the court itself described as the toxic and dangerous environment that had engulfed local government and its interface with politics. We are at the end of April, and a key public holiday is right around the corner, Workers' Day. And given this podcast is all about labor justice, I would say it's always important to reflect and recognize the rights and especially the dignity of workers. Wouldn't you agree with this, Debbie?
Actually, yes. Yeah, we're on the eve of Workers' Day, and moreover, we should reflect on the significance of the Samu judgment, which was handed down in April, the 9th of April, before we celebrated Freedom Day, which, of course, recognizes our first national elections on the 27th of April, which honors hard-fought political rights and freedoms for all South Africans, which find expression now in Section 19 of the Bill of Rights. And the case raises important questions around when are limitations of these rights justifiable?
Agree. And I think joining us to unpack the decision is the perfect guest today. We have Mario Jacobs, who was a previous guest on our show for episode 2, for those who haven't heard it. Mario is also a former SAMU organizer, regional secretary, and legal coordinator. So having spent more than a decade in SAMU structures, we actually thought Mario is best placed to speak on these issues. So welcome back, Mario. And I think just diving right into it, what are your initial thoughts on the case? Just tell us in 30 seconds, do you agree with the outcome?
Thank you, Debbie. Thank you, Aisha. It's nice to be back. I can certainly identify why the majority justices of the Constitutional Court came to the conclusion, but I equally identify with the minority judgment, particularly in the context of it being a policy consideration and the justifiable limitation as articulated by the minority judgment.
And Debbie, your initial thoughts?
Yeah, actually, it's a tricky one. I mean, without going into the decision itself, the problem of political interference and poor service delivery is a problem I'm sure, everyone wants to see resolved, which really, leaves us with a question about how do we address those issues. But in terms of the outcome itself, again, as Mario has indicated, I can see why the reasoning of the majority of the Constitutional Court led it to the outcome that we see in the case.
So let's unpack a bit more what, diving into your thoughts. Debbie, in particular, tell me, how does this case reflect the position of political rights of workers in our current law, especially in the context of international labor standards?
Yeah, I mean, I think in many ways, the case is a recognition of workers' political rights, and that political rights can't be suspended simply because workers are in the public sector. Especially when their roles, like workers who do clerical work, drivers, artisans, they're far removed from policy making, and therefore, the court's reasoning that limitations on the municipal manager or direct reports to the municipal manager, may well be subject to restraint. The idea of not having a blanket ban affecting all employees, that resonates with international law and international labor standards, the ILO's freedom of association and protection of political rights, and decisions we would see there. I think in many ways the judgment, it reflects what we would expect to see, and in many ways does not deviate from what would be considered to be a good practice in terms of the protection of civil and political rights. which we indicated we are celebrating this week. Hard-fought political freedoms. At the same time, we recognize that there's a problem that needs to be addressed, but the court has, pronounced that this is not the way to try to address that problem. And indeed, in many ways, that reflects with our obligations in international law.
You're listening to the Labour Justice Barometer, and we'll be right back. Mario, this is where now I have to come and turn to you. What would you say the key practical implications of this judgment for public sector workers are, and municipal governance? Do you think this judgment will actually have any impact on the parties going forward?
I think it needs to be clarified first and foremost that the judgment does not change anything that existed prior to 2022. Remember, the amendment only came about in 2022. So, in a sense, nothing has changed in the law. However, what needs to be said is too often, in my own experience, I've seen lower level staff members at municipalities, because they hold political office, they're able to influence key policy decisions that generally would be taken at a much senior level at that particular municipality, and they are able to do so by virtue of holding political office within that particular municipality. And there is a danger in doing that.
Debbie, what about you? What are your thoughts on this?
Yeah, I mean, I think, we haven't got to the heart of how do we solve the problem that Solga and Cogto were trying to address in this case. I think perhaps in a way they have attempted to address the problem in a rather indirect way, although listening to Mario in terms of his experience and what he has seen in the context of relatively junior members of staff holding political office, it comes then down to the question, I guess, and it is this balancing act around evidence-based policy making. And what would that mean? So, oddly, the majority decision in the judgment, feels that there was no evidence really presented about the problem, and to make the connection between this limitation on junior staff members as being one of the ways, the kind of connection between the limitation and achieving the purpose. Yet when Mario explains it the way he does, it does seem like that link could well be there. But the majority decision, sort of, states in the judgment, it's at paragraph 65, that no evidence was placed before the Labour Court that there is an appropriate relationship between the impugned extension, the extension of the limitation, and the stated purpose. Yet I think, we would all agree that the minority decision actually felt that there was adequate evidence. So there seems to be a bit of a gap, I think. Also, if we are indicating that, by limiting the rights of junior staff members, if we're indicating that limiting their rights to hold political office is not the solution, it might have been useful to have some insight into what would be the solution, what would be the way, the appropriate policy way to achieve the stated purpose, and why would that have been more successful than the type of limitation that Solga and Cogto were seeking to achieve through this amendment, this impugned provision that the Constitutional Court reflects on. The problem is that, it's a significant one. It's poor service delivery and violence and dysfunctionality that impacts on all of us. I do wonder, to some extent, especially hearing Mario, has the majority too lightly decided that this would not, go some way towards achieving the stated purpose, behind the extension. Was it a case of perhaps reflecting on whether, instead of a blanket ban, could it be qualified? Could there be time limitations? That the ban is in place? Could it have been not so much a blanket prohibition, but rather a process that needs to be followed before a staff member might hold political office? So I guess maybe back to Mario, if he can conceive of some alternative phrasing that might have survived constitutional scrutiny or some other, when we talk about evidence-based policy making, and when we talk about having a limitation, and the kind of that we can see the rational connection between the limitation and the purpose it is to achieve. Mario, can you envisage another way that this could have been achieved, or if this limitation could have had some qualifications on it? Maybe not everybody, but some form of qualification that could have withstood scrutiny and still been achieved a purpose.
I do think that there could have been a greater balancing act by the Constitutional Court between the policy intention, which is to depoliticize local government. I can't say whether time frame, I can't say whether to the level of supervisory function would have worked better. If we want to speak about political maturity and the delivery of service, then we need to have the discussion between the functions of a local municipality, which is to deliver core services to the local community, and those who hold political office. And in a sense, what we need to move towards is a greater sense of political maturity to realize the stated objectives as set out in the municipal systems.
When a political office is being abused by a junior staff member, or when service delivery is being undermined, it is about, how do we achieve that policy? I mean, in essence, are we dealing, if we look at it through a labor law lens, are we going into the realm of poor work performance? Are there other ways that we can manage this with the tools that we already have, rather than, of course, those can also be abused. So we're talking about here, the right to hold political office. It's a political right being abused. And you can also, envisage ways in which the right to manage workers' performance can be abused. I think it's a tricky situation that we find ourselves in. The judgment leaves us not quite able to fully criticize the judgment, yet acknowledging the problem that the respondents in the case were trying to remedy, and not really seeing a way that they could have achieved that, either through this mechanism, although it may well, listening to Mario, have gone some way to restore some level of functionality, possibly, or I think it's a tricky one, Asha.
I think it is a very tricky one. I mean, this is just us giving a, like we say, a teaser for people listening out there, because this was a very complex judgment. We had a lot of sessions of prep discussing this, and there's obviously been a lot of back and forth, and the conversation shouldn't end there. But I do think we have to ask our labor justice barometer question, and Debbie, how would you rate this judgment?
Yeah, Asha, again, if we look at our labor justice purely from this perspective of workers, this is a green for SAMWU, and the outcome certainly for the workers that that previously were prohibited from holding political office, and now having won that right. But what does it mean for the dysfunctionality that we see at local government level, and poor service delivery? Mario, your thoughts?
If we can move to a situation where holding political office should not advance the interests of the individual, but rather should advance the interests of the broader community, the broader society within that municipal boundary, then I think we will not be having this conversation. And I do think that actors within that particular space needs to act more maturely insofar as the proper functioning and operations of a local authority.
I think you put it very beautifully, Mario. And I think what this tells us is that while the judgment is a win in principle, I think realizing labor justice in municipalities is going to be ongoing. And I think, I mean, that comes to the end of our episode, and it just reminds us that compelling interests, like functional authorities and improved service delivery, it calls on us to find that balance. So I want to thank Debbie and Mario for joining us on the podcast, and for joining us again. We hope to have you on the podcast for future episodes as well, Mario. And thank you to you, Debbie.
Thanks, Asha. Yes, and to all our listeners, for Workers' Day tomorrow, wishing you a reflective and thoughtful Workers' Day, and how we can achieve that balance so that we have the degrees of maturity in terms of service delivery. Mario, thank you so much again for joining us and for sharing your thoughts with us.
Thank you.
This podcast is not intended to constitute legal advice.